call to order the board planning meeting for February 5th. And I will look for approval of the minutes of January 15th. Any other motion and second for the introduction motion? Motion will pass without objection. I'm sorry, 3 ayes, 2 excused, Supervisor Myers, Supervisor Carson. No need for closed session today, so I'm looking for a motion on the consent calendar.
Move consent.
Second. I have a motion and a second on consent. Supervisor Chan, second by President Aye. Is there objection to that motion? Motion will pass without objection. 3 ayes, 2 excused, Supervisor Carson, Supervisor Miley. Move to item 4 of the regular calendar, which is the appeal of Michael Shaw.
Yes, thank you. This is the appeal of Michael Shaw of the decision of the East County Board of Zoning Adjustments in their action issuing abatement order COD 2017-00843, declaring the property located at 8555 Dublin Canyon Road, unincorporated Castro Valley, 085A-800-8-1, that this property is in violation of the Alameda County zoning ordinance in its various sections, section 17.18.120, 17.52.515, the 1833rd zoning unit, and ordinance number O-89-3. So the East County Board of Zoning Adjustments on November 8th, 2018, issued an abatement order declaring that this property is in violation of the sections I just read. These were for unauthorized digital billboard, including support structures. So in summary, there's 2 support structures that used to hold 2 billboards each, and there's a 3rd support structure that currently holds an intact and functioning digital display billboard. The 4 billboards previously have been removed. It's just the support structures that remain. Planning Department recommendation, we recommend that the Board of Supervisors deny the appeal and uphold the decision of the East County Board of Zoning Adjustments to require the removal of all the billboards on the property, including their support structures, pursuant to section 17.59.140, and/or commence fines and fees pursuant to section 1759.200. Notification sent to the property owner included reference to Alameda County Zoning Ordinance section 17.18.120, which stipulates that any use of land within boundaries of the planned development, in this case the 1833rd zoning unit, shall conform to the approved land use and development plan. Staff also referenced ordinance number O-89-3, which is adopted in January 5th, 1989 by the Board of Supervisors, which further limits the type of signage allowed explicitly on the parcel located at 8555 Dublin Canyon Road in Castro Valley. The latter states that signage shall be limited to 1 non-electrical sign, a maximum dimension of 2 feet by 24 feet. That sign exists there. There's an identification sign for the business, the lockaway storage business that exists there today. Staff also, and that lockaway sign is perfectly fine. Staff also referenced Alameda County Zoning Ordinance section 1752.550, which provides general provisions in regards to billboards and advertising signs, stating that no person shall install, move, alter, expand, modify, replace, or otherwise maintain these billboards in unincorporated Alameda County. The property owners appealing the code enforcement determination and the East Bay EZA's decision ordering the abatement of the billboards. Their claims are that the judgment in the first federal lawsuit precludes county from ordering the billboards to be removed. Property owner asserts various other legal arguments about the county's abatement procedures and the East BZA hearing and order. However, the judgment and orders in the federal lawsuits rejected the owner's arguments that the county cannot order the billboards removed. So, because the billboards violate the county zoning ordinance, staff recommends that your board determine that the 4 unauthorized billboards and unauthorized digital billboard, including their support structures, constitute a public nuisance, and 2, recommend that your board adopt a resolution declaring the billboards to be a public nuisance and order the abatement of the nuisance within 30 calendar days. If such nuisance is not abated as ordered within a prescribed time period, county staff shall cause the same to be abated per ordinance section 1759-140 or commence fines and fees per zoning ordinance 1759-200. And that concludes staff report.
Thank you. Are there any questions? Supervisor Miley, I'm sorry. Hey, I'm thinking about Miley,
I
because
know.
this is his district, and I just
Yeah.
want to make sure that you state that he did say that it was okay if we go ahead with this.
He is aware that this item was coming up. We did brief him on that.
All right. I just want to make sure, just for the record, that I've looked at the packet since November, or is it September of 2017? We've been having this conversation with the owners of the billboards. Is that correct?
So even before then, June 10, 2014.
2014.
So in your letter, the board letter, there was a first notice to abate letter
Yeah.
sent
So-
out.
So what was the item that basically brought us to this conclusion where they've appealed and they've exhausted everything that they have? Is this their last opportunity to appeal this item? And have we exhausted from our side everything that we need to do to make sure that this is going to go forward?
Yeah, after the decision and the judgment that we do have the right to pursue enforcement, we're going ahead with the enforcement. Staff made the determination, was appealed to the East County Board of Zoning Adjustments, and this is the last appeal of that enforcement action.
And can this person go to court, or they already?
They could choose to, yes.
Okay,
They what? I'm sorry.
They could choose to, yes, they could go to court.
go to court. And in the meantime, the signs would stay up. Or not?
I would defer to counsel. We would pursue enforcement unless we get an injunction or some
Okay.
court order to stop the enforcement.
I did want to just remind your board that there is a detailed and lengthy litigation history already relating to this property. And so in one respect, this is sort of the culmination of a long process that involved extensive litigation. I don't know if you want to add anything to that.
I will just indicate that, as has been referred to, the matter before you today is the code enforcement matter.
Yeah.
Whatever your decision here today is, the property owner would have the right to appeal it or writ it to the Superior Court, your decision today.
All right, thank you. That's all I have.
Okay. Michael Shaw, and after Michael Shaw, I have Jeffrey. Jeffrey, I'm not sure what your last name is. Might be. Okay. Can you?
The continual pattern since 2002 of abuse imposed upon the County of Alameda, upon me. My name is Michael Shaw. I own a corporate 50% interest in Citizens for Free Speech, the owner of the billboards on I-580. Little history. Number one, the lockaway storage building permit. The process began in 2002 when the county suddenly stopped processing our CUP permit application for a self-storage RV storage facility on Crow Canyon Road. This action resulted in our filing suit in 2004. In 2004, the county was ordered by the court to issue our building permit. The court found that the county had inversely condemned the use of our land during the time in question. Overall, we were awarded $2.3 million in taxpayer cost damages. The county then appealed the condemnation award to the Court of Appeals. The court unanimously affirmed the trial court and awarded Lockaway additional attorney fees. Following the court process, we alleged that a specific member of county council continued to conspire to frustrate our rights. We sought redress in Superior Court without success. We then appealed to the State Appellate Court in San Francisco and filed our opening brief. The county succumbed and paid $500,000 to settle the claim. 2, property tax assessment. Lockaway distributed its assets to its 2 equal partners in 2010. I received the Castro Valley property. The county proceeded to double my property tax in 2010 on a project that was built 3 years earlier. They did this without giving notice to me of a hearing or even providing me an analysis of their assessment. Accordingly, I objected and I stopped paying my property tax. In early 2017, the Tax Assessment Board finally granted me a hearing on the reassessment. I was accompanied by 2 counsels and an MIA appraiser. The hearing opened and my professionals were prohibited from presenting our case. The taxes remained inappropriately high. Last month, I sold the property to pay the taxes so that I can file suit to reverse this wrongful assessment. This week, I will file that suit for refund. I do not sue government unless I should win. I would be willing to work to settle this claim with any of you acting in representation of the county. 3, billboards. In 2014, a new partnership of mine put signposts to hold 6 billboards along the Lockaway streetscape. Upon erection of those boards, we sued in federal court, alleging that sign coordinates in Alameda were unconstitutional. We prevailed, and again were awarded attorney fees. Since our victory, the United States Supreme Court has ruled that commercial billboards are now subject to a higher level of government review, so-called strict scrutiny. This makes it virtually impossible for government to control the content of billboards.
Mr. Shaw, your time has expired. I'll allow you to wrap up.
Thank you, Mr. Higbee. The county intends by new ordinance to require abolition of the signs in 7 years without compensation. Have you ever read the Fifth Amendment to the Constitution? Why are you subjecting the taxpayer to such liability, that is, for taking our speech boards? In a more recent federal court action, the record was set straight. The court denied issuing an order prohibiting you from this proceeding today. Then in its final order, it said when the matter gets in front of a judicial officer, that means the next court, the court will be bound by the federal court holding by Judge Charles Breyer regarding this matter. In other words, an adverse ruling to citizens by this board today will be negated by any court reviewing it. Number 4, misdirected county administration. The county, under the direction of ABAG leader Scott Haggerty,
ABAG leader? It's okay.
has fully embraced ABAG. ABAG is the Bay Area's Council of Government, or COG. ABAG rearranges American local government into a newly unelected regional form of government, replacing the power of elected city and county governments. ABAG has a $300 billion program designed to create a Bay Area-wide city-state with its own seat at the United Nations. ABAG is now partnered with the Metropolitan Transportation Commission, the MTC, in order to funnel federal financing to ABAG's One Bay Area plan. Mr. Haggerty is now vice president of MTC.
Vice Chairman.
Vice Chairman, I'm sorry. ABAG is unelected, funded, and seeks unlimited control. It seeks to implement policies known as Agenda 21, also known as Sustainable Development. Since 2000, I have been a productive voice across the country against Agenda 21 and an active opponent of ABAG since 2005. I suspect this is why you have been convened to destroy our billboards. Your participation in this serves no one, just tyranny. Do you have any questions?
Are there any questions? I think we're all familiar with
All right.
ABAG and MTC, but
I'm just about.
I just had a
wrapped up.
question. So they said that the billboards have been taken down, but not the structure. So did you who took down the billboards?
We took them down.
You did?
Yes, we decided to take our ABAG signs down to relieve pressure on people like Mr. Baggerty. We do intend to reestablish those boards.
that sounds like a threat.
How so? That we're going to electrify our signs and continue advertising?
You just threatened me that you're going to put up signs against me.
Not necessarily.
That's what I heard.
Well, let me clarify.
Okay, all right. No,
We
your
have we have not decided
your
what
time's
sign.
up. I know, based on maybe how I vote, but you know what? We sit on boards
Well, you can conclude
all
what you
over-
want.
All over the United States, we sit on boards. And I have been assigned to ABAG by this body. I have been assigned to MTC by this body, just as others have sit. Supervisor Chan, I believe, sits on BCDC. We all sit on various bodies, and that is done as our work through being a member of this Board of Supervisors. So I don't want to debate you. I apologize, but I would like to call Mr. Herson now.
Well, let me say, I've got several more pages, which I'll
No, you're
direct
done,
to you.
sir.
Well, I will direct them to you. I have copies.
Thank you. I probably let you speak for 7 minutes, and it was only a 3-minute time limit. So
Well,
thank
you know,
you,
it's
Mr.
been
Herson.
20 years of pure harassment from your board, and you were on the board in 2002, beginning that process. That was when I was fighting Agenda 21. Once I started fighting ABAG, the intensity got worse.
The 2002, 2004 timeline, that was the Measure D timeline, wasn't it?
Measure D does not apply to lockaway storage. Of course, the court record is absolute about
It's
that.
in the Measure D area, isn't it?
It's, yes, Measure D was
It's in the,
adopted.
it's in, that's not really true. It's in the Measure D area, which is where we got tripped up. We thought we couldn't process any more applications during that time in the Measure D area, which you went to court and you successfully won.
Very easily, because it was a pretty bold misreading of Measure D to apply it to lockaway storage. Court concluded that, and if you looked at it fairly, you would conclude the same thing.
Okay, all right, thank you. Mr. Herson?
Good afternoon, members of the board. My name is Jeff Hurst. I'm here on behalf of Citizens for Free Speech. Hopefully this won't take more than 3 minutes, but I think it will. I have issues with the staff report that was provided to me. And they said that on September 4th, 2014, the federal court issued a preliminary injunction temporarily barring the county from continuing its enforcement proceeding. However, the court later rejected all of one of the property owner's challenges to the county code. The only claim on which property owner prevailed was the county code section 1752520A. As it existed at the time of the lawsuit, violated equal protection clause of the United States Constitution. What I have in my hand here is the order for motion for preliminary injunction from Judge Breyer. Page 12, he says, the zoning ordinance gives officials too much disapproving signs based on their content. Too much discretion, unbridled discretion. He found that to be violative of the First Amendment. He also went on to say that the ordinance also had too much discretion. The Public Works Agency had Historical Landmarks Commission have unfettered discretion to approve and disapprove signs. 17520R. Found that to be unconstitutional. The document that your staff provided does not reflect what happened below. The reason that he didn't declare it unconstitutional at the end of the case in the judgment was because you guys were forced to fix it. You fixed those provisions, which stripped us of having a judgment based on these provisions of the code. So our signs were built when the sign ordinance was declared unconstitutional. So fast forward a little bit. You guys came back after us in 2017. We want you to tear your signs down. We said, okay, you want us to tear our signs down. We go back into federal court. We asked the federal court judge to put a stop to it. You know, she decided she didn't want to do that. But one of the things she said, which is telling, see if I can read from her. Plaintiffs argue that the county's abatement claim is barred by the doctrine of claim preclusion on the ground that such claims could have been asserted in the prior action in the form of a counterclaim, but was not. Res judicata, also known as claim preclusion, bars litigation in a subsequent action of any claims that were raised or could have been raised in the prior action. Owens v. Kaiser. However, this doctrine is inapplicable as the county is not seeking to relitigate any claims against plaintiffs in this or any other court. What is she saying? What she's saying is once this gets to a court, which it will, when you file your notice of writ or execution of writ, whatever you're going to do to try to take the signs down, we will have a defense. It will be res judicata and claim preclusion. You will be barred from taking further action. Number two, let me see if I can pull this up. CCP 426.30, Code of Civil Procedure provides, this is the basis for it, except as otherwise provided by statute, if a party against whom a complaint has been filed and serves fails to allege a cross-complaint, which you guys didn't do it, any related cause of action or at the time serving his answer to the complaint, he is against the plaintiff, such party may not thereafter in any other action assert against the plaintiff the related cause of action not pled. We sued you, we wanted the billboard invalidated. You should have counterclaimed against us saying, nope, the ordinance is constitutional, we want your signs down. You guys didn't do that. That was the fatal flaw with your mistake. And now you're trying to bring this board to have the signs taken down. It's not the right way to do it. Thank you very much for your time. Do you have any questions?
No.
No, sir.
So, I guess of council, I'm not sure where this whole ABAG Agenda 21 and all, I don't even know what Agenda 21 is, so. But as far as all this is concerned, I did feel in that discussion that my vote has been threatened, and I'm curious as to how I respond.
Repeat the basic of your question, not the preamble. I heard the preamble, but the actual question.
I feel like my vote was threatened.
Do you feel like you cannot be impartial in hearing the matter today?
No, I feel like I can be impartial. I'm more worried about the threat.
Thank you for giving me a moment to consider this.
We can take a recess. If you want. I didn't know it was okay to threaten a public official on their vote.
Yes, and whether you want to proceed with this matter and address that issue after your board makes a decision, you could do that, and then we can look into it.
I've been doing this for 22 years, and I've never been threatened on a vote in a public forum. So I don't know how to respond to it. And if you need a few more minutes to get an answer, I'm willing to take a 5-minute recess.
Why don't we take a 5-minute recess,
I'm willing
please?
to do that. Thank you.
Call Supervisor Bryant. Yeah, you have to call it. All right, we're all here again. County Council?
So I understand that there was an exchange in the chambers, and I've been briefed on what occurred. It's my understanding that Supervisor Haggerty was subjected to comments that he voted a certain way, that he would, that the speaker would take an action against him. The county respects the rights of individuals to express themselves in a way, or want to participate in the public process, and to express themselves within the bounds that the Brown Act permits in a public meeting. You know, if my understanding of what was stated was that he voted, Supervisor Haggerty voted a certain way, that there would be actions taken to, I guess, in effect, retaliate against the supervisor by pursuing some type of campaign on billboards against the supervisor. It's my understanding that the supervisor was asked whether or not he could participate and still vote impartially, and that he would not be, and that he responded that he could, and that he would not be swayed by any threats that were attempted to be used to try to sway his vote or intimidate him into voting a certain way. As long as the steps that would be taken on the billboards would be steps that would be protected by free speech, then I think this proceeding should proceed because the county does not have a policy of discouraging appropriate free speech.
Okay, thank you. So with that, I have no other speakers on this item.
Mr. Chairman, I'd like to move the staff recommendation denying the appeal and upholding the decision of the East County Board of Zoning Adjustments. Require the removal of all billboards on the property, including support structures pursuant to section 17.59.140, and or commence with fines and fees pursuant to section 17.59.200.
Just a final clarification.
Excuse me, just a point of clarification that the board would need to order the property owner to remove the sign. If not, then the county would commence with the abatement and or fees.
So that the person remove the signs and the county will commence with fees.
So, can you repeat what you said? I have a motion to second, but I just, Supervisor Dyer didn't quite respond to what you did, so if you could just say what you meant again about the county?
Yes.
What you said is that we're asking the landowner to remove the signs. If not, we will remove them and then having fees associated with that.
That is correct.
Okay, is that what you meant?
Yes, but I was, again, just reading the staff report,
Oh.
and what you mentioned, I didn't see in the staff report. The recommendation.
I think that may not have been as clear as it could, but I think the way Supervisor Hagley restated it is staff did.
All right, to be clear, there's a motion and a second. Is there objection to the motion? Motion will pass 3 ayes, 2 excused. Supervisor Lyman, Supervisor Morris. We'll move to item 5.
Yes,